ayes, in favour.
So I've left my glasses on my desk. I can see you all right. I can't see this. Can you hold on for a second? It's not far. Right, thank you.
Thank you. Just, if I can come back on two short housekeeping
Yes.
into the morning. The first one is in relation to documents. We're still compiling those, so we propose to produce them tomorrow morning. That's the first point. The second point is in relation to the insurer point. There is a paragraph in the judgment that assists, but I understand we're still trying to make sure we have a clear picture on this. But paragraph 306, page 163. There were specific questions asked by the list of issues, and this is one of the list of issues, and it relates to paragraph 4.6 of the handbook. And this is the last sentence. I know my learned friend wants to ensure that was a submission in relation to all legal rights, so that's the point that he might pick up tomorrow.
Thank you.
If I may, I'm going to move on to crystallisation, which is a point we've touched upon already, and it's where we say there is an error at paragraph 250 of the judgment, which is page 148. It's a short point, but we submit important. We've already looked upon this, which is why I'm not going to take too long on it. The judge essentially draws a distinction.
So sorry, which paragraph did you say?
Paragraph 250,
yeah.
Page 148 of the core bundle.
Thank you. Yeah.
In this paragraph, towards about halfway down, it starts, however. The judge states there's a fundamental difference between those who are funded by the insurance policy and those who are funded by TUI. For the former group, the insured risk has already materialised. That is, the pilot who is covered by the policy has become sick is entitled to benefit within the terms of the policy paid by the insurer to TUI. The point is simply that the materialised or the risk is that of the point occurs at the point of incapacity, and that is the same whether or not there's an insurance policy underlying that risk. The judge seeks to draw this distinction because ultimately what he ends up finding is that the rights of those over 60 has been changed, but those under 60 are likely to be protected because of this insurance policy. So it's an important distinction because he uses it to make a distinction between the under and over 60s that are in claim.
Well, clearly is a distinction, isn't there? But the question is whether it's a relevant distinction for the particular point he was there making.
Well, we submit...
What is the point he was there making, which you say he wrongly applied it to?
So he's talking there. He then goes on to talk about the fact that there is a industrial, potentially legal consequence if the insurance policy doesn't then follow through to the individual employee, i.e. if TUI, for instance, decides not to pay it because they could do that now that the collective bargaining allows the PHI Handbook to be changed for in-claim pilots. I think the point I'm trying to draw out is that it is not how the handbook is written. There is no distinction between the risk materialising whether or not there's a policy behind it. And the crystallisation point is important because then that is part of the framework of how he then addresses the collective bargaining elements. And I submit that, unsurprisingly, when you look at the contract, it refers to the trigger event being the incapacity, and that is when the risk develops. So there's no distinction that should be drawn in the way that the judge does in this paragraph. All individuals, all pilots that become incapacitated have had their risk materialised. It essentially seems to be aligning the two contracts, the employer-employee contract in the 2015 handbook and this underlying insurance contract, which we say is effectively relevant to the entitlements under the handbook. I don't intend to take you to the case. If you refer to Pelter in the skeleton argument, and that's paragraphs 21 and 22 of the skeleton argument, which talks about when the risk materialises or crystallises. That's paragraph 63. Essentially, it says what I said already: benefit crystallises at the date of incapacity. And for your reference, that's Authorities Bundle, page 469. The point is also dealt with in McMahon, which is a very recent case decided in April of the Court of Session. Again, I won't take you to that. I think my learned friend behind me will take you to that. It's at tab 26, and it's paragraphs 41 and 44. I should just say one further point on this, just in relation to this idea of collective bargaining changing the benefits, that we've forgotten or haven't referred to more recently GIP-GAPA. As you may recall, that I referenced them before, where they are in-claim pilots who, for which again there's no insurance policy underlying them because they became incapacitated after the insurance terms were not renewed at the beginning of 2020. And of course, they are also a pool of individuals for whom they could have their rights taken away because there's no insured policy underlying it.
Well, who says they can have their rights taken away because there's no insurance policy?
But through collective bargaining, because that's the point the judge draws at paragraph 250.
Yes.
Which is there's a difference between those with an insurance policy underlying it and those that haven't. I'm going to deal with the last point under ground one, which relates to a concession, which is set out in paragraphs 260 to 262. And the key part of that is, so it starts with a reference, page 150 of the core bundle.
So sorry, I was just writing. Which paragraph?
It's paragraph 261 is the key.
Yeah.
It picks up the second sentence. As Mr. Williams' case has pointed out, and in respect to which there's no real challenge, most of the claimants accepted that they could have agreed individually to a variation of PHI benefit which they were receiving, and this would have not amounted to an imposition of changed terms. You will see from the respondent's skeleton argument they rely on that concession as important to explain why they say any change in clause 5.1 doesn't mean that. For the purposes of you'll note I don't necessarily take you to it, the two concessions are recorded at paragraph 80 of the judgment, which is page 105 of the core bundle. That's Mr. Gavin, who essentially accepts that any pilot on a personal level could, on a personal level, negotiate to change the effect of paragraph 5.1. And the second concession is that of Mr. Crabb, and that's paragraph 82. It runs from page 105 to 106. He accepted a personal variation of income benefits could be agreed with the company, but he didn't accept that boundary representatives could do that on his own behalf. I'm not going to spend too long on this, other than to say that that concession really reflects the concept of contract law, that two parties to a contract can come up with a new agreement. And as I understand it, in practice, the time when that might happen is where a lump sum is paid out under the insurance policy rather than the individual being paid monthly amounts. I think that's the practical point where you might have a different agreement. I submit that that concession does not undermine the interpretation adopted by the appellants. And in fact, it really just reflects the basic understanding of what contract law means, and it therefore shouldn't be given the weight that it has been by my learned friends. In essence, just looking at what that means effectively, it's a form of mutual consent. So we're looking at that sort of wording that's used in Tesco versus your store, but that doesn't mean that collective bargaining follows, which is effective, as I understand it, what my learned friends are saying. And in fact, that's clear from the decision in Tesco. Mutual consent is just that between the parties. Collective bargaining is something different. And then just picking back up on Tesco, obviously what the Tesco is looking at is effectively there's the permanent obtained pay. You've got an express recognition and individual parties can change that according to each other, so mutual consent being the employee and Tesco. And they could still agree if they wish to change that permanent benefit. Despite that, obviously, the mutual consent didn't allow collective bargaining. And so essentially, it's the same concept that we're arguing for here, which is that you've got effectively a robust stabilising promise of any changes being protected, and that coexists with the principle that the same contracting parties might, at some point in the future, agree a new bargain. The fact in Tesco that the parties could agree a new bargain doesn't change the underlying permanence of that retained pay clause, and we submit that the same principles apply here. Until a mutual agreement is agreed between, we submit, TUI and the individual pilot, we say paragraph 5.1 stands, or the second sentence paragraph 5.1 stands undiluted, and again any change means any change. That is the last point that I wish to make in relation to ground one. Just summarising, if I may, briefly where we've got to. We submit that the proper interpretation is, firstly, the first and second sentence are not linked, looking both at the natural language used, but also the context. Secondly, we submit that reference to any change necessarily includes change by way of collective bargaining. Submit that, again, that change is consistent with the literal meaning of the words, the context in which the sentences are found in the handbook, and the intention of the parties of the contract. It's also consistent with the overarching purpose of PHI, that once incapacitated, the employee knows with certainty what income protection they will receive, and that protection cannot therefore be eroded. Finally, it doesn't, we submit, produce absurd results in the way that I have explored. My lords and ladies, I'm going to move on to ground two, unless there's anything else you wish to ask about ground one.
Don't think so, thank you.
I'm grateful. Ground two can be dealt with briefly. You will have seen, undoubtedly, from the respondent skeleton that at paragraph 53 they accept that the judge erred when in law by stating that Balfour was acting as the appellant's agent. That's page 60 of the core bundle. They go on to say it makes no difference. I submit that is wrong. And I think just to remind ourselves what that relationship looks like, I'd ask you to turn up the Supreme Court in Time and Where Passenger Transport Executive versus the NURMT, tab 25, which should be the second appeal authority bundle. And it's page 626.
So which page?
626.
Oh, I see, that's where the thing is. Yes, but which particular page you take us to?
I'm going to ask you to look at 645 paragraph 40. They look there at the nature of the relationship towards the second part of paragraph 40, where they look at what the nature of collective bargaining is, and I wish to pick up on that. We do not discern either in the general nature of collective bargaining arrangements or on the facts of this case any agreement between the employees and the recognised unions under which the unions were authorised by the employees to negotiate terms on their behalf. Although it may be said, and is said, for example, in Schedule A1, paragraph 35 of the 1992 Act, that a recognised union conducts collective bargaining on behalf of employees falling within the relevant bargaining unit, this phrase must be understood in a loose sense to mean that the union is acting in the collective interest of those employees. It cannot mean that there is, in law, an agency relationship between those. And it's also probably helpful to read paragraph 41 of them. Don't turn to it at this point.
Well, this is all very basic stuff.
Yes, I agree, but the judge got it wrong, my lord.
Well, he used the wrong word, but it's not clear it affects the substance of his reasoning at all.
Well, firstly, my lord, I submit words matter.
Well, they don't. They matter. They may matter, or they may not, depending on the substance.
Well, but I think that it belies his misunderstanding of what is happening in the collective bargaining process and that machinery.
But surely what happens in a collective bargaining machinery is that where the employee has agreed in advance that the product of collective agreement will be incorporated in their contract, the effect of such an agreement being made is that it becomes part of the term of their contract. Now, whether the machinery is called agency or whether the machinery is called, find some other word for it, representation. In Court of Appeal in this case, I use the phrase on behalf of, because I thought that didn't necessarily mean by way of agency, obviously. But whatever phrase you use, the important point is that your contract as an individual is automatically changed by what the union negotiates. And that's all the judge was saying. And the fact he said agency is neither here nor there, is it?
Well, my lord, I'm respectfully going to disagree with you on that.
Please do.
Because I disagree in two ways. First of all, I do think it matters because of the way that he looked at consent.
Perhaps we should see the paragraph. Where you say he went wrong.
My lord, yes. So he refers to agency in two paragraphs, 264, which is page 151.
That was all you wanted from Time and Where.
My lord, yes, my lord, yes.
Sorry, paragraph
264, page 151.
Thank you.
And then also 278, which is page 155. My lord, he uses those words as I've set out, but I submit that it infects the way that he's looking at this idea of something being consensual. So, for instance, at paragraph 263, he talks about it being consensual collective variation.
But it is consensual, isn't it?
Well,
it's consensual because the employee has agreed in advance to accept what the union negotiates.
But,
that's all he means.
But my lord, there's a second the second point that I disagree with, which I haven't come to, is around this idea of it being automatically incorporated.
Oh, right. Well,
and that's the fourth round of appeal, which I will come up with, because I submit that's not right. That in fact there needs to be a further analysis, even with what my learned friend calls the seminal provision, which I'll use now to refer to the incorporating clause that's included in the individual contracts of employment. So it's not simply that there is consent, because I submit it's more complicated than that, partly because of the ground 4, but it infects the judge's approach, because when he is looking at what collective bargaining is and means, I submit you can see that he is, I submit, muddling the concept of the union and employer coming together and arriving at a non-legally enforceable contract, or not contract, agreement.
Not enforceable between the two of them.
Between the two of them.
Yeah.
That then, because of the seminal provision, may or may not be incorporated into the contract.
Well, why may or may not? Will be. Providing it's apt for incorporation,
yes.
But that's a different point.
Yes, subject to it being apt for incorporation.
Yeah.
That's
well,
correct.
so you say may or may not.
That's the aptness point.
Yes, I see. Okay, fine. Sorry, I distracted you from the main point you were making. I've got down it infects the judge's approach because it muddles the union and the employer making an agreement which will be incorporated into the employee's contract. Muddles it with what?
Muddles it with firstly the correct legal framework, but also the proper relationship between the various groups. So the employees, pilots that are in claim, the union and the employer. My Lord, if I may, can I just take to that second paragraph that I think might also show this perhaps slightly more plainly, which is paragraph 278, paragraph 155. Page 155. Again, this is in answer to the specific question asked in the list of issues. And he's looking at did the defendant breach the claimant's contracts of employment as particularised, and the judge says, insofar as I found that these were consensual variations through the agency of the union and that the change were incorporated into individual contracts by virtue of MA, these breaches cannot be established by introduction of the changes. So it's the concept that there be consensual variations through the agency of the union, something is wrong. And it's not a matter just of...
But I still haven't quite understood. Give it to me one more time. We agree that as a matter of law, the union is not the employee's agent. It's a rather technical point, but it's one we all recognise. But, provided the product of the collective agreement is apt for incorporation into the individual's contract, the effect of the collective agreement is that it is incorporated. If the judge had said that rather than using the word of agency, his point would have been just the same, wouldn't it?
Well...
If he'd said through the mechanism of the collective agreement or something like that?
My Lord, I think perhaps this is a slightly different way that I'm looking at it, which is it's when he's interpreting paragraph 5.1, he's looking at it through this prism of Balfour being enabled to act as agents and to therefore be consensual, and it feeds into where he comes up with the unilateral versus non-unilateral a way of changing things.
So you're saying that the achievement of a change by collective agreement is not consensual in the same way as a change effected by something your agent agrees on your behalf.
Yes.
Wow.
And also...
You've agreed, in either case, you've agreed to the legal mechanism which has produced that result. Even if you have an agent, you often don't agree. You don't know what they've done. You're stuck with what they agree for you.
My Lord, perhaps I can go back a step, which is that, and this goes back to the Tesco case, mutual consent, i.e. consent, is a concept between the two individuals that are party to the contract.
In that context, that's clearly what it meant, yes.
But I submit that there's no difference here. Consent can only be between the individual pilot and TUI. So it's muddling what is happening, and that feeds into, I submit, the mistaken interpretation of paragraph 5.1.
Thank you.
My Lord, if I move on to ground 3, which is in some ways mirrors a little bit of what we've discussed already. The appellants submit that the judge's approach to collective bargaining and the role of BALPA was fundamentally flawed, and that in turn led to the conclusions that he arrived at in relation to the construction of paragraph 5.1, but also to the process through which he finds the PIP MOA varied the contracts of employment of those individual pilots. He essentially concluded that the parties had already agreed how change would occur, that collectively bargained amendments to PHI made via the PIP mechanism validly varied the pilot's contract, and that paragraph 5.1 didn't carve out PHI out of that process. It goes back to the point around, if that was the case, there needs to be specific wording in second sentence of paragraph 5.1 to have that. Which obviously is not there. And the respondent characterises the seminal provision as effectively advanced consent to any future variation introduced by collective bargaining, such that essentially consent to all their contracts had already been given, and it didn't matter if the appellants later withheld their consent. So that's effectively what the respondents say. So picking up on that, essentially, ground 3 is challenging the judge's conclusions on the role of an impact of collective bargaining, and that we submit tainted interpretation of clause 5.1 on the impact of a role of collective bargaining. If I can just go back to the judgment, again at paragraph 250. At paragraph 250, you'll see that there is reference in the fifth line down. In other words, in the absence of any consensual variation, this provision is to be construed as contractual, which ensure in-claim pilots, regardless of age, that they will be protected from unilateral change modifications. And you'll see there's an asterisk by, number 28, by the words consensual variation. And that's because in the asterisk it says that will be dealt with below, and it's not entirely clear where it's dealt with below, but I understand from reading the judgment that he's dealing with it essentially at paragraph 262 and 263.
Yes, well, more generally, I think that under the heading starts above 259.
Yes.
Yeah.
Yes,
that
exactly.
was my understanding as well.
Yeah, I agree with that. And he then goes on to look at what he means. Essentially says that each individual pilot consented to the change because of their contracts of employment containing a seminal provision. And then he comes up with this term at paragraph 263 where he calls this consensual collective variation. And that paragraph 264, protection of paragraph 5.1 did not apply to variations agreed by BALPA, as those variations were not imposed. I've already taken you to China Ware versus RMT, and it's a similar point, but if I may take you to Frampton's versus Badger, which is tab 2 of the bundle. Tab 10 of the bundle. And it's page 73. Just by way of background, it is an employment case relating to an enhanced redundancy package and whether or not that continued to be contained in individual contracts of employment where the collective agreement containing it can come to an end. You can see that in paragraphs 4 and 5, and if I may just take paragraphs 23 and 25. It's just in which the judge looks back at some of the cases, Alexander in relation to terms and conditions and collective agreements, and then having looked at the case law, which she does in paragraph 30, there's a summary of the principles that have been gleaned from these cases, and so I think it's a helpful summary of the way it's looked at in terms of the relationship between union and collective agreement and employer. Some of this is, some of it might be fairly basic, but collective agreement is not legally enforceable. That's paragraph 31. And we submit that's important because it's not that the individual pilots are giving consent to the individual changes, but of course it can be incorporated by the seminal provision. And
sorry,
then,
where's the reference to consent?
Sorry, that's my reference. It's the sentence that starts, however, the rights and obligations found in collective agreements can bind employer and employee by being incorporated. So the point is the incorporation term. And that's
yes,
even
well, okay, but he doesn't say that that's not a form of consent, and what it clearly is a form of consent.
Well, it's silent to that, my lord.
But surely sorry.
No, my lady.
But by agreeing a contract of employment that has a clause in it that says the relevant collective agreement will be incorporated, the employee has consented to the incorporation of the collective agreement, subject to the act for incorporation point.
My lady, I understand the point you're making. I think in the light of this particular handbook, where you've got permanent, we submit rights, the idea of consent, and as I say, go back to the Tesco cases, consent is a narrow concept. It's a slightly different framework. They haven't, generally, yes, they provided the power for the collective agreement to be incorporated. That's right.
Yeah.
But in terms of consent, they haven't individually agreed to anything in relation to the Schedule B memorandum that was introduced in 2021. I think that's the judge obviously says that because he asked the question, I think it's paragraph 261. The real question is whether or not a collective agreement to such a variation was permissible when none of the in-claim pilots had themselves agreed or consented to changes. And you may decide it's a matter of semantics, but I said it's important because of the way that you're approaching, again, this interpretation of paragraph 5.1. If you are saying that individuals have consented, it's easier to take away their rights. And which is essentially what's happened here. These individuals lost the benefits that they otherwise would have been entitled to. And so I submit it's not simply a matter of semantics, it's the way that the use of consent empowers, I submit, wrongly the judge to arrive at the interpretation he does.
Well, I obviously get the point you're making. It's obviously significant these individuals didn't individually agree and quite clearly wouldn't have agreed if they'd been given any notice beforehand. But that's not really what this case starts from that point. And the question is whether, if you don't like the word consent, whether the mechanism to which they are bound by, the mechanism to which they have agreed when they signed their original contracts of employment. You say it's not just a matter of semantics. I think you just don't like the implication of the word consent, that they really did consent. But we all know they didn't consent individually, so you needn't think we're going to be fooled by it.
My Lord, I'm grateful for that indication. Yes, and I think that, obviously the use of the term collective consensual variation certainly it's not a term
This is written by a lawyer, and I know these are very important human questions to people. The judgment written by a lawyer, quite rightly, that's what he is. And consent is the word we use the whole time in a contract to mean, and you can consent by an agent, you can consent in all sorts of ways. And I honestly not thought time spent on this word is going to advance the argument.
My Lord, I'll move on then, if I may. I just want to say one further point on this, which is around intention, because when again looking at the contract, we're looking at the intention of and when I say contract, I mean the 2015 handbook. We're looking at the intention of the employee and the employer, and BALPA, what BALPA do after that, obviously got nothing to do in relation to that intent, because again, the muddling I submit of the collective bargaining process and how he uses that to inform his interpretation of paragraph 5.1, I submit demonstrates that he's bringing in the intent in relation to his collective bargaining negotiations into his understanding of what paragraph 5.1 means, whereas in fact he has to look at it at the point that the contract's entered into in 2015. And of course, just to remind you again, the handbook wasn't collectively agreed. It was effectively written by TUI.
I mean, talking about intent doesn't really help either, does it? Because it's just another way of saying the meaning of the contract. If you actually look at the intentions or what the parties would have intended if they'd thought about it, if you ask the employer at the time, should we be able to depart from or modify crystallized rights, if we agree that with the unions, they might well have said, yes, I think we should. And the employees would probably say, well, I don't think you should be able to. So looking at the subjective intentions doesn't get us anywhere. We've just got to look at what the words mean.
My Lord, that's correct. The only thing I would say on that is if that was something that, TUI could and should have thought about, then it should have been expressly stated.
I suspect neither party thought about it. But I agree. The individuals clearly won't have, because they weren't doing the negotiating.
Yeah.
But,
and my Lord, I think
anyway, I take your point. You said, I'm speaking myself, I've certainly got this point, that if it was going to have this result, which to the employees at least would be a surprising result, it should have been spelled out.
Yes, my Lord, that's the point.
Yeah, you take that from AMDocs, but probably don't need AMDocs for that point anyway. Yeah.
My Lord, I'm going to move on to ground 4. There's a dispute between the parties as to whether or not there needs to be a consideration of a term that's being introduced by a collective agreement on the basis as to whether or not it's apt or not apt. I just want to pick up first of all on a pleading point which is taken by my learned friends in relation to whether or not it's in a list of issues. It's paragraph 6 of the list of issues, which you can see, just so you have it written down in front of you, is at paragraph 276 of the... it's at page 155, just below paragraph 276. If each or any of the paragraphs 2.1, 3.1, 4.6 or 5.1 of PHI Handbook were incorporated into the claimant's individual contract of employment, were such terms varied by the incorporation of Schedule B to the memorandum agreement between BALPA and TUI. The point was made by the appellants that you need to pause and consider aptness. That point is recorded in the judgment at paragraph 171, and it's page 127 of the judgment. And after some discussion, the authorities the judge records my submission, it was still necessary to...
Which paragraph do you say?
171, it's the
Thank
very
you,
last sentence. It was still necessary to consider whether individual provisions would act in corporation in the context of the overall employment contract. And again, just to take up that there's reference in the respondent's submission to paragraph 216, and they say that shows the judge, the learned judge referring to
216, did you say?
yes, so 216, page 137. And I just want to put that in context because here, and it starts at page 132, are the defendant submissions being set out by the learned judge. And so it's not that the learned judge said there's been no allegation pursued by the claimants that the collective agreement's terms were inapt. That's a point that's made by the respondent. So we say it's plainly in front of the judge, and it isn't necessarily part of whether or not...
Well, theoretically it is, but in the substance of this case, how could they not... If it has the effect alleged, how could it not be apt for incorporation?
So, Milo, can I narrow it down? So a chunk of the respondent submissions about whether or not the terms would be apt or not apt. I agree, generally they'd be apt. Our point is much narrower, and you're right, my lord, it hinges on the interpretation of clause 5.1, paragraph 5.1. So if
it's just another way of putting your five, but I think you may be using the wrong label. Apt for incorporation, as we just saw Justice Elias saying in Brampton, is basically means that if you've got a collective agreement which has a clause in it that is entirely aspirational, so it's not contractual certainty and so on. It's not the sort of clause you would find in the individual contract. So that goes. And then the other one, which is actually historically where the phrase first came up, was where the union and the employer agree things like the union can have an office free of charge on the premises, or we will meet once every 6 weeks and follow the following procedures. Those are not matters which would belong in the employment contracts of the individuals. To me, that's what's meant by apt for incorporation. And it sounds to me as though you're making a different point, using it with respect, or what seems to me the wrong label.
Well, I take it from the case of Hallett versus Derby Hospital's NHS Foundation Trust, which is tab 17, again called for appeal, and it's page 309. So I'm not sure if that's the first or the second one. Tab 17.
First bundle.
Thank you. And it's page 336, paragraph 94.
So not in fact called for appeal.
Oh, sorry, apologies. You're right.
Sorry, can you tell me the paragraph again?
Paragraph 94. So this is just, they're looking at the question of aptness.
Yes, well, I haven't, that's not the term in which I think it's more usually used. To say, would it be inconsistent with the other terms of the contract?
And that's the point, my lord, that I wish to draw out.
I see.
Because we'd say it's not apt for the Schedule B, so far as it relates to in-claim pilots, it's not apt for incorporation because it's inconsistent with our interpretation of paragraph.
Okay, well, I'm glad we clarified that, because that's not what I understand by apt for incorporation. But it's your point is that it would be inconsistent with what 5.1 had said.
On our interpretation, my lord, yes.
Yes, but then that really is just another way of delivering your main point. If your main point is right, you don't need this, because the parties would have already agreed that this couldn't be changed by collective agreement.
My lord, yes, that's our primary argument. But as I said, it's been put that there's an automatic incorporation, and effectively that overrides.
Well, there is an automatic incorporation. If you've agreed beforehand, suppose you had in your seminal, I can't remember what the phrase is they use, that in what I think of as the incorporation clause, if you said, I will be bound by everything in such and such a collective agreement and any revision from time to time, except any revision relating to holidays, say, then a subsequent memorandum of agreement by the union, which proposes which changes your holiday entitlement, wouldn't be incorporated because you hadn't incorporated in the first place.
Yes, my lord, that would be right.
Yes. Well, if that's
it's two ways of Iceland getting to the same result, which is that the PHI benefits continue to exist for in-claim pilots on our interpretation. But I thought it's important to draw out because of the proposition that Schedule B automatically incorporates.
Well, if that's really what Mr. Williams is saying, he'll have a hard time persuading me if by automatically it means that whenever your union agrees something for you, it's automatically... You have got to agree beforehand to that kind of thing being agreed. Mr. Williams is nodding. If you haven't agreed beforehand to that kind of thing being agreed, the fact that the union could go on agreeing until they're blue in the face, it won't affect your contract.
Yeah, and obviously we say that's the impact of the second sentence of paragraph 5.1.
Yeah, no, I see that.
And my lord, just on that, I don't mean to by any means, but I just want to point out two further authorities which just deal with this sort of point on Appellants, which is Keeley versus Fosrock, which is tab 9, and Osaic versus Tesco Stores, which is tab 16. And the respondent referred to two other cases, which I submit our cases effectively are more recent and higher court, but they refer to Edinburgh Council versus Brown and Mawson versus XL Logistics as supporting their proposition that collective agreements are automatically incorporated.
Well, I thought we cleared up that misunderstanding. Mr. Williams nodded.
I just wanted to address the authorities ones, so you have them in front of you. So, I don't think it's in dispute, obviously, that the judge didn't consider Appellants, but partly probably because he never got there. But in any event, if you're with us on the interpretation, then we submit that the PHI benefits continue, whether or not you get it through looking directly at clause paragraph 5.1 second sentence, or whether or not you look at this Appellants point. My lord, those are my submissions on the fourth ground. Unless there's anything further that I can assist you with, then I will pass over to my learned.
Yes, thank you very much. Mr. Selwood.
Thank you, my lord. My lord, I'm aware of the pressures of time. I shall try to treat this relatively discrete set of grounds quickly. As you'll no doubt have grasped, they're concerned with the termination date of the PHI benefits. Age 65, according to the judgment and the respondent, or state pension age in the claimant's submission. It is correct to say that these are ancillary grounds, in that they only become relevant if you're with my learned friend on the effect of 5.1, because plainly if we're wrong on 5.1, it doesn't matter what PHI said, because PIP has come into effect. However, if my learned friend is right, my submission is that the termination date of PHI benefits is of central importance, because otherwise no one is quite aware of what one of the fundamental terms of the PHI contract actually is. It's also correct to say that ground 6 is really the central submission here, given the way that the learned judge approached this at first instance. The other grounds exist effectively because of what we say is the unclear nature of the judgment and the exercise which the learned judge was actually carrying out when considering state pension age or age 65. In terms of the provisions in question, I won't labour the point, obviously you've been taking them already, but just briefly, my lords and ladies, to look at them. The clause 2.1 is a supplementary bundle 54. And we can see in clause 2.1 there are two mentions of the if higher your state pension age language. The first is in the second paragraph. You will generally cease to be included in the plan when you reach age 65, or if higher your state pension age, or earlier if you cease to satisfy the eligibility conditions. I'll come on to that. If you leave the company, you will also cease to be eligible for inclusion in the plan. And then the next paragraph, which as was pointed out earlier, is pilot specific. Please note that if you are a pilot, whilst you will be eligible to be covered under the plan until you reach age 65, or if higher your state pension age, on reaching age 60 your cover or any benefit and payments which may become payable will be provided in accordance with the plan terms by your company rather than the insurer. So that's two mentions of that language in 2.1, and then over the page 55, under 3.1, we have those 4 bullet points that my learned leader took you to. It will be payable until the earlier of the following: you return to work, your incapacity ceasing, reaching your 65th birthday, or if higher, your state pension age, or your death. So, in that contract, in those terms, there are 3 separate mentions of the phrase, or if higher, state pension age. My learned friend took you through a number of authorities. I don't propose to repeat that exercise. However, I would beg your indulgence in turning to tab 17 of your authorities bundle, which is Hallett. Which my learned friend took you to briefly. My lord, you're of course right, this isn't a Court of Appeal judgment, it's the Queen Bench Division. It is, of course, Mrs. Justice similar as she then was. I don't say that in any way determinative, but one might consider that she has something to say.
Good start.
In terms of employment law. And I'm looking, my lords and lady, at page 336 specifically. And apologies, the sideline doesn't seem to have made it up that far. I'm looking at 91 first, because Mrs. Justice Simler helpfully sets out a stepwise process, as it were. First question: have the parties expressly or impliedly agreed that a document should form part of the contract? There's no such agreement, the inquiry stops there. But then, if there is such an agreement, there remains the further question of which the terms of the document are apt. And then we have some discussion in 93 of Keeley, which I'll take you to later. And then at 94, the starting point in determining whether a statement or provision is apt for incorporation is the wording of the provision itself. The natural and ordinary meaning of the statement or provision read in context must be considered. Secondly, consideration must be given to whether the statement or provision, if incorporated, will be inconsistent with the other terms of the contract. If in clear language of entitlement and not inconsistent, it will be incorporated irrespective of the context. But if inconsistent with other terms, it will not be incorporated. The key point of all of these grounds, in my respectful submission, is simple. What the learned judge at first instance has done is taken a few words, or if higher, state pension age, which occur in 3 separate parts of these clauses and judicially redlined them, extracted them. He's incorporated everything else around them, and yet these specific words he's reached in and extracted. And what I submit on behalf of the claimants is that is impermissible as an exercise.
Again, you can go to be in my bonnet about aptness for incorporation, but the real point here is what happens, and this doesn't necessarily only happen in collective agreements. You get two provisions, or a provision which is internally inconsistent with another provision of the same contract, or possibly with some clear statement of the purpose of the contract. The judge says, well, I know it appears to mean this, but look, this is what they say they were trying to do. If they include this, it's the opposite of what they said they were trying to do. When I was learning contract law, which was a very long time ago, the people still talk about repugnancy. This provision is repugnant to the rest of the contract. And then you do just strike it out. I can't remember what the cases are, but there are lots of them. And that's just common sense. People make mistakes in contracts, and you can get such radical inconsistencies that you say the whole contract falls because you can't work out what it means. But courts hardly ever do that in practice. They say clearly this little phrase or this bit, this particular provision, is inconsistent with all the rest and can't therefore have been what the parties meant. And isn't that really what we should be thinking about here, rather than this or that phrase or this or that authority?
Well, I think, my lord, there are a few answers there. The first is that if I've gone wrong in terms of looking at aptness for incorporation as a concept, that is because that's precisely how the first instance judge deals with this. The entire portion.
Well, all right, but judge, we're the Court of Appeal now. We can do it. we can look at the real point of the judge's reasoning, whatever adjective he used, was here is a benefit which says on its face this is intended to replace your salary, and therefore it can't go on after the latest date at which you could have got a salary. And he said this provision is so obviously inconsistent with the declared provision, purpose of the contract, that it must be disregarded. Now, whatever label he used isn't really what matters.
Abandoning labels then, taking
Yes,
that point
thank
head
you.
on.
I don't. You can use them if you want. It'll help me if you don't.
I'll try not to. There's really, I would say, two answers to that. The first is, it is either, I think my primary submission would be not inconsistent at all, or secondly, in the alternative, certainly not so inconsistent that it can displace three separate mentions of the same phrase, which can't possibly have been a mistake. This isn't the case of the parties getting the wording wrong once, oh, it's an error. It's there repeatedly. It is quite plainly part of the fundamental framework of the contract. In terms of the inconsistency, the benefit being paid out by PHI to pilots is 75% of their salary. It's not a replacement salary, it's 75% of their salary. In those circumstances, plainly one looks at the context and one can say, okay, on one hand, they're paid 75% of their salary, on the other hand, they get it for longer, so that they have certainty. There's nothing inconsistent or wrong about that. If the judge had said 3.1 in its mention of replacement salary is so crucial, he should have said, well, they're going to get 100% of their contract as their benefit. Because it has to be a replacement salary, it has to be like for like. But of course that's not the contractual scheme. The contractual scheme is, as is usual, one has commercial trade-offs. Less money for longer, less money for certain. But that's what's happening in my respectful submission, my lord. And cutting out all of the terminology, which might allow me to be rather quicker, a point I make in my submissions is that effectively that replacement salary point is the one thin reed that the first instance judgment supports judicial redlining of a key term. And again, in my submission, that is simply an error of law. It is the judge descending into the arena of rewriting the contract of the parties, and that cannot be right. Avoiding too much discussion of aptness, I think probably it is right to look at a couple of authorities. The first being...
Yes, of course. Don't let me... Sorry. When judges say, let's get to the heart of it, that doesn't necessarily mean you aren't allowed to go around the edges a bit. So.
I do understand.
Okay. Which is the authority?
So Keely and Fosrock, my lord, which is at tab 6 of the authorities fund. Again, mentioned briefly by
Sorry, tab 6.
tab 6 should be. No?
No.
I've obviously
You're going
down wrongly, my apologies.
Keely, tab 9.
Page 65. Apologies, Harry. This is a Court of Appeal judgment which in my submission gives an extremely helpful rule of thumb in terms of aptness for incorporation or whatever else one wants to call it, and that's at paragraph 36, page 71. Thinking about incorporated documents, the judgment says this. I probably should start at 35 so you have some context. Equally, if not more important, is the wording of provision under question in an incorporated document concerning contractual terms. If put in clear terms of entitlement, it may have a life of its own, not to be snubbed out, etc. And then 36. With respect, the judge seems to have overlooked or given insufficient weight to this fundamental starting point in considering the aptness of the enhanced redundancy payment provision in its own right to be a contractual term. If apt by the nature of the subject matter and on its own wording, there is no doubt that it was incorporated by reference, etc. As Lord Justice Dyson noted in the course of Mr. Brennan's submissions, a good way of testing Fosrock's case and the judge's reasoning on construction is to ask whether, and subject to the issue of certainty, if the redundancy policy had been set out in identical terms in Mr. Keely's statement of employment terms, it could seriously have been argued as a matter of construction that it was not apt for the contractual term, and on that account, not part of the contract. And perhaps that goes, my lord, to your point of however one considers it, aptness, repugnancy, or anything else. Can one
Well, he really isn't dealing with a repugnancy. He's just dealing with a suggestion which one used to see quite often, that redundancy is a sort of discretionary benefit and you wouldn't find it's not contractual in nature. I can't remember what the exact facts of Keely and Fosrock were. But that is a better use. That really is a case by aptness. But suppose the redundancy payment had some provision in it which was completely contradictory to something that appeared in the rest of the contract which already existed, then you would be much more in the territory that we're in here.
Well, my lord, for the reasons I've already given, I say in my submission, I don't accept that. I
see that. I'm just trying to get the argument straight in my mind. Now, I see exactly why you say there isn't an inconsistency. Effectively, as I understand it, you're saying, well, all right, it's meant to be a replacement, but it's not 100% replacement, so there's nothing unsurprising in the quid pro quo being you're only getting 75%. We're happy for it to go on a bit longer. Yeah.
And then, briefly, my lord, if we can look also in the authorities bundle at the case of Hussain and Surrey and Sussex Healthcare NHS Trust, that's tab 12. And I'm looking particularly at page 176. And of course, this is a High Court judgment, but it's been referred to in numerous cases as being helpful. The learned judge in this case, at paragraph 168, sets out a number of what he calls indicia, probably not pronouncing that right, 5 of them, as to when thinking about aptness, what kind of factors should one consider? And I take you to this, my lords and my lady, because in their skeleton arguments, the respondents make great play of factor 5, whether the provision is workable, or if enforced it wouldn't be workable or make business sense. And in fairness to them, that's a factor that's mentioned by the learned judge as well. It doesn't make business sense. Of course, what the learned judge doesn't do, certainly not explicitly, and I say not really implicitly either, examine the other factors. For example, number 1, the importance of the provision to the contractual working relationship. Well, when the benefits end, is in my submission also important. The level of detail provided by the provision. Is actually, whether it's so complicated the court shouldn't get involved, but actually our term in my submission is not complex at all. It's just a date or an age rather. Third, the certainty of the provision. Well, it's entirely certain. And 4, importantly, the context of the provision. Our terms, or if higher state pension age, are contained within clauses which the judge has expressly said are all incorporated, other than those 2 words. The context couldn't be more powerful for their incorporation, in my respectful submission. The judge, with respect to him, doesn't seem to have considered those factors. He's effectively said, I think this is a bit nonsensical. I don't wish to go too far in being critical, but as I say, really has descended into the arena and written the bargain in a way which, in my submission, judges should not.
When your initial submission was that it's not inconsistent at all. Which provision did the judge find it was inconsistent with?
So it's at 3.1, I think. It's the very first paragraph. The plan, that's supplementary bundle 55.
Yeah.
The plan aims to provide you with a regular income benefit while you remain in your company's service. This benefit is designed to act as a replacement salary. And it's that phrase, replacement salary,
that you have to read it, the next sentence too. This is what had been expected by pilots who are no longer able to fly. The windfall of a benefit extending beyond their normal flying age made no contractual sense.
Sorry, I'm not sure where we are.
Oh, sorry, you were reading us from, weren't you, from paragraph 257?
No, I was actually reading from the primary document, but
Oh, I'm so sorry. I was reading the same thing in the.
So it's the. I understand. So your submission is that taking all the factors set out, for example, in the Hussein case, there's no reason to. In particular, when you look at the paragraph that deals with if you are a pilot, not to side that it's appropriate for incorporation, or it is not inconsistent with.
Yes, Judge, my lord, sorry. You've hit on my next point, which was that specific mention at 2.1. It's not the case that this is a general provision about poor if higher state pension age, and they just haven't thought about the position for pilots, and it's all very anonymous and wrong. There is a specific provision in 2.1 about pilots, and it specifically says, or if higher state pension age. In my respectful submission, that is extremely powerful evidence.
Yes, but I think what the judge is saying is that for non-pilots, this was a perfectly sensible thing to say because of age discrimination and so forth and all that. It didn't apply to pilots, but they had just adopted this formula and they put it in throughout the handbook, both to even in the bits which only apply to pilots. That seems to be perfectly plausible. It's not a complete answer, but you could see how it might happen.
Well, I think that goes back, my lord, to the general principle that the court should not attempt to rewrite a bad bargain for parties. If TUI have been so careless as to effectively write a contractual term which puts them on the hook for something they didn't want to be put on the hook for, well, tough. If you're
You could say that's exactly the line I took in the Tyne and Weir case.
I don't think you did well tough, my lord, but yes, more erudite language, but yeah.
No, no, effectively, I accept that. But there's the difference here that it's not just a bad bargain, but the judge's point is it's inconsistent with what they themselves have said the purpose of this benefit is. That's really his point.
I think you have my
Yes,
suggestion.
no, I take that.
I can't really take it any further. Moving on, though, of course, there's the respondents of other limb. Respondents in their skeleton arguments, as I understand it, say, well, even if you're with Mr. Selwood, it doesn't matter because of the EU regulation. Pilots can't fly commercial aircraft after 65, so we simply dismiss them.
You speak up a little.
Sorry, perhaps I just need to...
You're a long way away.
So the second limb of what the respondents say is the European Union regulation means that pilots can't fly commercial aircraft after 65, therefore we can simply dismiss them. That ends the contract, and that's the end of it. So it doesn't matter if higher state pension age is in the contract or not. In effect, they make a no difference argument, even if I'm right on incorporation. And there are a few points here, my lords and my lady. The first is to say, this argument was before the learned judge at first instance, and he expressly chose, in my submission, not to make a finding in respect of it. So I'm looking, and I think this may be the paragraph that my lords were looking at earlier. I'm looking at paragraph 257, the core bundle 139. Mr. Williams seeks to challenge this alleged entitlement on the basis that eligibility ceased when employment ceased, and a pilot who was in receipt of benefit had no option but to accept retirement as a pilot at the age of 65. However, I do not consider that such a construct is necessary. So, in terms of the first instance judgment, that was before the judge. He hasn't made a finding about it. We can see...
Sorry, when you say he didn't make a finding about it, he wasn't... I must say, I thought it was just established by accepted by both sides as a matter of law that he would have had to retire as a pilot at 65 because of the civil aviation regulations.
No.
Was that disputed?
Absolutely.
I didn't know that.
Perhaps I can take you
Yes.
to it. So it's at Authorities Bundle tab 30.
Sorry, before you get there, was it disputed below?
Yes.
Is there a bit somewhere else which shows your submissions about it? Somewhere else in the judgment?
My learned leader might be able to assist. It's certainly in our skeleton argument because I know I put it in there.
Oh, I see. So there's nothing in the judgments which reviews the arguments about this. So
No,
that
because
would
he
be
simply said
shorthand.
not needed. I mean, I think
Fine.
I think there is some mention in the judgment about the general issue, but
Right.
as I say, no holding made. He felt it was unnecessary. What 173? I'm told, my lord.
Page or paragraph?
Paragraph. Page 128, paragraph 173.
Yes, I see.
Yeah.
Oh, well, not accepted the regulation by the compulsory retirement age of 65 for pilots. This only restricted those over 65 from acting as pilots of commercial aircraft. But weren't the claimants all employed as pilots of commercial aircraft before this happened, before they got ill?
Yes, mate.
So it would have required them to retire from their jobs at 65.
If they were actively at work as pilots, but they weren't. None of them were able to work as pilots.
No, quite. But this is a benefit meant to replace your salary as a pilot. That's of a commercial aircraft. I mean, TUI are a business, aren't any recreational aircraft.
No. But it comes back in my submission, my lord, to that earlier point. What is the bargain between the parties? And if you're with me on my first point, then the bargain is we will pay you 75% of your salary as benefit until state pension age. as a pilot. It explicitly says that. So, yes, they're employed as pilots, but they can no longer fly planes. They have entered into a contractual promise with TUI that they will continue to be paid. Actually, conditional on their status as pilots. If that weren't the case, what on earth would be the point of that specific provision in clause 2.1? Why would TUI or anyone else have said anything about pilots going to state pension age if they were automatically going to retire? It would be completely meaningless. So my submission is, if you're with me on that element, then the bargain is to state pension age. It's part of that deal, the trade-offs that are made commercially. In effect, the claimants, or any in-claim pilot, can't fly commercial aircrafts a day before their 65th birthday. They can't fly them a day after their 65th birthday. It makes no meaningful difference to them at all. Their contract continues, and continues to have the same effect that it did at age 64. That's my submission, my lords and my lady. Just in terms of the understanding of the parties and what was going on, we can see that in the correspondence which was extracted by the learned judge in the judgment at paragraphs 106 and 107 of the judgment. This is in his various discussions of the evidence. And he's extracting an exchange of emails between TUI and the insurance broker in 2011. First, on 28th of September, the broker says, Matt's understanding of the compensation cover of pilots is the same as mine. TUI were only covering them to age 65, not 65 SBA or higher. That said, we understand and note that pilots can't remain employed as pilots after age 65. Therefore, if we assume if any such pilots remain with TUI after age 65, they're effectively re-employed as such, as non-pilots, etc. But TUI respond the next day. Hi, Catherine. I've not had a chance to call you, but I've discussed with Nick. We believe we should keep the pilots on the same basis as everyone else in terms of retirement date being 65 SBAF higher, but rely on their contractual terms to ensure that even if on PHI, they will cease to be employed at 65 and so will come off the benefit. In this way, we have set ourselves correctly for the future, but can still manage the pilots. So, my lords and my lady, in my submission, effectively what's going on here is TUI is saying, yes, they have a contractual right to SBA, if higher, but we're going to retire them at 65. So that contractual right won't and doesn't matter. That's important in my submission because it runs entirely counter to the face of the now well-developed jurisprudence, which ends with Usdaw and Tesco stores, which my learned friend has taken you to.
How did the judge deal with this exchange in his reasons?
Sorry, my lord, I couldn't hear.
How did the judge deal with this in his reasons?
I'm not sure.
Is that 258?
258. Ah, yes, quite right. So 258. He said it's clear that consideration will be given to the potential anomaly. Changes to the HB were not immediately introduced on the basis that pilots would compulsorily retire at the age of 65 at any event. So what I say is
that refers to another element you haven't yet. It's not simply that they couldn't fly when they were 65. after they were 65, but also that the benefit would cease when they were retired, when they were dismissed, well, either when they retired or were dismissed at age 65. And all Mr. Tate is we'll do it by sacking them rather than, or making insisting they retire rather than by altering the terms of the handbook.
In my submission, that's precisely what happened, and that's precisely what, given Tesco and Usdaw and McMahon, you're not allowed to do. So perhaps it would be useful firstly to turn to Tesco.
It's rather different facts from Tesco and Usdaw, isn't it?
Well, I say Tesco and Usdaw, drawing on relatively long line authorities now, established general principles. So it's tab 24. First useful paragraph is probably paragraph 56.
Hold on, tab 24.
Yes.
Sorry, did you say paragraph 56?
Yes, so paragraph 56.
Yes.
The red line extends all the way back to paragraph 51. I don't intend to take you through it, but effectively the Supreme Court reviews the line of largely PHI cases.
Yes.
Which say you can't simply sack someone because they're a PHI and you want to stop them being a PHI, and that's a very loose paraphrase.
Yes, but I thought that stopped at the retirement age, but I suppose you're okay, I now see how it works. It says if the retirement age is the state retirement age, that's the point at which
Yes.
that's the only the right protected by that line of authority goes on up to. You know,
And I might well be in more difficulty, my lord, if there was a contractual retirement age, but I think it was established in the court below that there isn't. There is nothing in the contract saying when they're going to retire.
yes, I see.
So just briefly at paragraph 56, the principle I say is cited there. The promise that retained pay will remain permanent contractual entitlement for as long as employment in the same role continues and would have continued absent that right means there's an analogy. Retained pay represents an important part of the total consideration for which the claimants work to continue to work as the value of the benefit was offered as a significant inducement. And then a little bit further down in the same paragraph, there is no magic in the nature of the particular scheme involved. These cases exemplify the principle that a term implied by fact may be required to qualify an employer's otherwise unqualified contractual.
So which paragraph are you on?
So I'm now towards the end of paragraph 56.
Paragraph
5.6.
5.6.
My submission, my lord, is it's important. It says there is no magic in the nature of the particular scheme involved. These cases exemplify the principle, etc. So there's a principle being established there, which I think I paraphrased rather inelegantly as you can't dismiss someone because they're on PHI and you don't want to pay them PHI anymore. Which I say is precisely what TUI are doing in their argument. Their argument would simply be defeated by this principle, which is now well established. Even more recently, as my learned leader mentioned, there's the case of McMahon from last month, albeit of course it's in the Court of Session, so persuasive. That's at tab 26 of the authorities finding. And the first paragraph that's perhaps useful for situating yourself in this case, 5. So it was a claim for unauthorised deduction of wages. See, AXA argued its only obligation was to arrange and pay for a suitable permanent health insurance policy. Failure in that regard not being capable of triggering a deduction of wages. However, it was held that so long as Mr. McMahon was an employee and unable to work, AXA itself was contractually obliged.
So where are you reading from now?
Paragraph 5.
5.
Contractually obliged to meet the scheme payments. So that's what it's about. Someone on PHI, AXA contractually obliged. That person was sacked, and then if you look at paragraph 41, further on, looking at the end of the second line, the key submission for Ms McMahon has been that the implied term negated the dismissal. Whilst we may not couch the notion in those exact terms, we consider that the general idea has been too readily dismissed. Essentially, AXA placed itself in the position of an insurer promising to pay certain benefits so long as the eligibility conditions were met by Ms McMahon. Since incapacity for work was one of those conditions, it makes little sense if that alone allowed the payments to stop. If the implied term prevents dismissal on the grounds of incapacity, why should dismissal for that reason receive effect, thereby precluding enforcement of the contractual PHI entitlement designed to thwart? Now, of course, I accept that this case is specifically about someone dismissed for incapacity, which is a rather more powerful and one might say obviously wrong action for an employer to take. But I say it's another application of the principle in Osborne and Tesco stores, and you can see it, paragraph 37 onwards. That's where they get the principle from. So really, in my submission, my lords and my lady, that the case of McMahon shows that this principle is continuing, has been established, and still exists. So in that context, my submission is it's simply incorrect to say that the contractual terms, or if higher state pension age, make no difference. TUI can't dismiss. The pilots would have continued to state pension age. And of course you have my earlier submissions about why that's a contractual term and should be given effect as such. Only really remains for me to very briefly...
So the way this would have worked, would have had to work, is that they would have had to remain nominally in employment to whatever the state pension age was in that particular case, say 67, and couldn't have been effectively dismissed, at any rate if the only purpose of dismissing them was to not to have to pay the amount.
So it doesn't affect, for example, right to dismiss for gross misconduct. That still exists. It's when the purpose is, as I say the judgment and the documents show, to subvert the contractual right. You can't do that.
Yeah, well, I mean, this has never been tested. It's not as if they've ever done it, but that. So it really does have to turn on the question of the fact that they couldn't have done the job for which they couldn't have done their contractual job. I've flown as a pilot of a commercial aircraft after 65. That's what it all has to turn on.
Yes, and I wonder if I make one other point briefly. If we look back at page on the supplementary bundle, page 54, which is the clause itself. Look again at 2.1. I think it's only right I refer you to this in any event, whether or not you agree with my submission on what it means. Looking at the last paragraph of 2.1. So this is just after the pilot's specific paragraph. It says, if you leave the company, you'll also cease to be eligible for inclusion in the plan. Please also note that on reaching age 65, if you remain employed by your company in a non-pilot capacity, and you are able to satisfy the insurer's actively at work requirement, you will be eligible for continued PHI cover, should then be insured in line with the standard stance for non-pilot members. So my submission, my lords and my lady, would be the first pilot-specific paragraph tells you the general situation. If you're a pilot and you remain incapacitated, and you don't get another job at TUI, you remain till state pension. If you're a pilot but you manage to get a ground-based role and you continue working in that ground-based role, then you can get the benefit on that basis up to 67. I say it reinforces the point that the people in the claimant's position, i.e. incapacitated pilots who don't have a ground role at TUI, continue to stay pension age, and that's their contractual right. So very, very briefly on ground 7, it's fair that the respondent's right to some extent, and perhaps this is somewhat academic in that because of the learned judge's findings, ground 7 doesn't quite come into play because he found that it's or if higher state pension age language simply wasn't incorporated in the contract. However, it's important briefly to mention, because if you are with me on ground 6, there is a hint in the judgment that the judge may have been saying that TUI could simply have changed matters in 2019 and that became the new contract. I should explain, in 2019, TUI changed parts of the handbook unilaterally, without consultation, and they got rid of the or if higher state pension age language and crossed it out. And really, ground 7 is there to ensure that if I'm successful on ground 6 and my learned friend is successful on her grounds, the respondent can't turn around and say, but we changed the contract in 2019. And I say it follows logically from everything the judge found at first instance that TUI couldn't in 2019 unilaterally just cross out the language. That must be true. And so it's rare, really, it's a belts and braces approach to defend the claimants from any misinterpretation of the judgment. I think that's all I need to say on my grounds, unless I can be of further assistance.
No.
I should check with my learned leaders.
Sure.
Thank you.
Thank you very much. Yes.
My lord, I'm conscious of time. Is the court stopping at 4:30?
4:15.
4:15. Understood. I will then be going over tomorrow. I just want to make, if I may, some general points of principle before setting out what seems pretty obvious now to be the only issue in this appeal. And the points of principle are obvious ones, but worth restating. My learned friend said it, that, let's try it, law, obviously two parties can agree to vary the terms of any contract between them. And in an employment context, that's done in invariably two ways. One, the employer and the employee talking directly, the first one. And the second one is what we're concerned with, this appeal is concerned with today, through collective bargaining, where there is an incorporating provision, to use the words of Lord Justice Underhill, or seminal provision as is referenced to by the judge. And I would submit, perhaps nothing turns on it, but they're both forms of consent. Both forms of the employee consenting, one through a bilateral discussion with the employer themselves, the other is you consented through the incorporation term to your employment contract being varied automatically by what your trade union and what your employer agrees. Now, Lord Justice Underhill already stated this, and it is worth restating, that with the second form of contractual variation, there are always going to be winners and losers in an industrial, not always. Often there can be winners and losers in that industrial bargain. And that means for some, as indeed in this case for the claimant, there could be potentially negative effects to their terms and conditions. Now, it seems pretty obvious.
Sorry, just for, in case it's of any relevance to the analysis, you say two ways in which the parties can vary the contract, either by individual negotiation or by collective bargaining, or a third one, not very common in the employment context, but still possible, by a genuine agency agreement. The employee says, I'll leave it to so-and-so to negotiate this bit for my solicitor, or high-value contract may actually be negotiated by someone else.
Yes, with a CEO or something. Yes, that is correct, my lord.
Yeah.
But what seems obvious now, having heard the way the appeal is now put, there is really only one central issue before you, and it is whether 5.1 properly construed prevents collective bargaining, because otherwise, normative effect, the seminal provision, the incorporating provision, has automatically varied the claimant's PHI terms to PIP. Now, my lord, it's already been stated by the court that these are pretty basic concepts. I'm conscious I don't want to labour the points, but there is still some wisdom to be found in a couple of the earlier authorities, just in terms of the language that this court uses. And if I may, I'd like to take the court to the first authority, which is Robertson and British Gas. That's behind divider 2. I'm very familiar with this, but it's more the language Lord Justice uses, and Lord Justice Kerr. Now, some pretty august advocates, if you see who page 8, you'll see a future Home Secretary and a future Lord Justice of Appeal. Mr. Howard QC was for British Gas, and Stephen Sedley was for the employees. But, I mean, the principle is that if a collective agreement or term from a collective agreement is incorporated into an employment contract and that collective agreement lapses, absent variation of the employment contract, those terms continue. Now, if I can take you to page 11, Lord Ackner's judgment, there's page 11, sorry, of the authorities bundle. It's actually page 356 of the authority. And we look at E and F on the right-hand side. Do you see that?
Starting.
Well, if I start, well, perhaps if I start between C and D, it is common ground. Do you have that, my lord? It is common ground that one goes to the collective agreement made between the employer and the trade union. And it talks about this collective scheme in existence, which clearly set out there was a bonus entitlement. And then just below E, it says from time to time. You see that, my lord?
Yes.
The collective scheme modified the bonus, which was payable, and when that occurred, in my judgment, that variation became part of the employee's obligation to pay. So the principle of normative effect there. Then just a bit further down, just below F, the collective agreement could, as occurred in this case, be determined. It lapsed. But that did not determine the tariff which had originally been imported into the agreement, the tariff being the amount of the bonus. First when the agreement was originally made, and then altered as time went by the consensual agreement between the trade union and the employer. And it's the words by the consensual agreement I just want to take this court to. Not the criticism of the judge that he gets his language wrong, but here we have this court using that very language. It's a consensual agreement between the union and the employer, but it then gets incorporated into the Mr. Robertson's employment contract. And just a bit further on at G, if I may, it says it follows, in my judgment, that under the letter of the 1970, that tariff could not be affected by the unilateral determination of the collective agreement. So again, that the concept of an employer trying to unilaterally change the terms and conditions and the limitations to that. And then I want to take you, again, just the language of consensus. The judge isn't, our judge in our case, the then judge, isn't coming up, is not creating this language. It is grounded in long-established authority. If I take you to the last page of the authority, to the page 13, and it's at C, we're now on to Lord Justice Kerr's judgment. And it starts with, I agree with Mr. Sedley's submission. You see that?
Yes.
And it's, again, that the wording, when the terms of the collective agreements were varied by consent between the two sides, then the new terms clearly became incorporated into the individual contracts of employment. Again, that reference to consent. The two sides being the trade union and the employer. And again, I just want to take you to the bit that follows after it, but what does not follow, in my view, is that the contracts of the individual workmen can be varied by some unilateral variation or abrogation or withdrawal from collective agreement by either side.
Why
why are you emphasising that point? I mean, that's an important and interesting point, but it's...
Well, it goes to the unilateral, which will come back to the construction point, which I'll get to. I'm starting, if I should have said it, I'm starting taking the court first through the principles of normative effect because it grounds the proper construction, we say, of 5.1. Now, in order to, the authorities I've referenced in the skeleton argument, Higgins and Mawson, I don't propose to take you to them other than I've referenced them because they just effectively restate the principle but show the individual employee may go, hang on, I don't agree to that. But if he's got an incorporating provision, that is ultimately tough. And again, to make good the point about the winners and losers in a collective bargain arrangement, there's paragraph 42 of Frampton's. Mr. Justice Elias, as he then was when he was president, the Employment Appeal Tribunal, making that point. And that it would be in the foreseeable contemplation of the parties agreeing, in this case the employer and the employee, including when you agree in incorporation provision, that it, some terms could be to your detriment.
So, 42, did you
Yes.
say? Page 90.
Correct, Madam.
Yes, the employees legally take the risk the union might renegotiate an agreement, which is to some extent to their detriment.
Yeah, and that could obviously include accrued terms as we potentially one had in Tesco and indeed in this case, if absent a carve-out of collective bargaining. Now, before I get to the construction point on 5.1, I will deal briefly with 2 and 3. Grounds 2 and 3, we call the agency point and the consensual variation point. Now, obviously, the judge erred by referencing to agent, but I would echo what Justice Underhill said. It doesn't make any difference. You could change the word.
Well, I was putting your points.
You're putting my perhaps more elegantly than I'm about to. But yes.
Thomas Mayhew. Yeah.
But that is made good by when you look at his analysis. You could replace the word agent with principle or whatever the word is you choose to replace, but you still get to the same analysis. He looks at. I'll take you in a minute, but in summary, he looks at was there a collective agreement? Yes. Was there incorporating provision? Yes. Therefore, it became part of the employee's terms and conditions, whatever label he was using. Because if I perhaps take you to paragraph 261, which is at page 150 of the core bundle. It starts, do you see, the juxtaposition of the two provisions?
Sorry, which paragraph?
It's paragraph 261.
Thank you.
I believe it's on page 150.
Yes.
And the paragraph starts with the judge juxtapositioning these two, the two rights in 5.1. Then he makes reference to the concession that some of the claimants made about that, well, it wasn't preventing them individually agreeing to change their accrued rights or their PHI benefits. And he asked absolutely the right question here at the end of the paragraph. The real question is whether or not a collective agreement to such a variation was permissible when none being claimed pilots had themselves agreed or consented to change. So he's absolutely putting front and centre of his reasoning. He knows that the claimants aren't in the first of those three ways in which one can vary employment terms. That wasn't before his mind. It was very much whether collective bargaining could do that. And then, which is paragraph 262 is a critical part. In my judgment, this is answered by reference to the contracts of employment of each of the pilots. That's the page, the next paragraph on my lady and my lords. And that includes the relevant MOA. The consensual validation was validated by the creation of the collective agreement. So that's the first stage in how employment terms can be varied through collective bargaining. Was there a collective agreement. And the reference to consensual variation, that's very much in keeping with the language this court was using in the 1970s in Robertson, in respect of which each employee had agreed would be incorporated into their individual contracts. Now, the footnote there references some extracts from the employment contracts. And I'm conscious that you've not been taken yet to any of the particular contracts, but just as a sample, right, it's in the core bundle at page 300, sorry, the core bundle, the supplementary bundle, page 388. You have a contract with Mr. Gavin, and just so you can see that the primary source of the works.
Sorry, when you say you,
The supplemental bundle, page 388.
I think page 12.
Yes, sorry, it's confusing. Right, there are several references. Page 12, and it starts. You see between the two hole punches, memorandum of agreement.
Yes.
And this employment is subject to the provisions of an MOA between the company and Alpha. The existing provisions of this agreement, and crucially the word subsequent provisions thereto, are deemed incorporated in your terms and conditions of employment, and a copy you can be requested for. So, paragraph 262 is he's taking himself back to those individual employment contracts. And he's very much applying the principle of normative effect, absent the carve-out principle, the 5.1. So, my lady and lords, there is obviously an error by referencing the word agent, but the analysis is still sound. And the same point is made for the references to consensual variation as well. Well, in terms of ground 4, I now understand, and I know a friend will correct me if I'm wrong, but really that is effectively restating a different variant of ground 1, because it can't, the language one uses, PIP can't, it's not apt, it can't be incorporated, whichever the language is, because of 5.1. That's why I understand that appeal. I get to the two sides of the same coin, so I will deal with that in the context of ground 1. And perhaps before I get to ground 1, my lord, because it in part goes to consent, but it also informs the language that is used in 5.1, or isn't used, we would say. Now, my learned friend obviously put Tesco before you, and that's precisely what I'm going to do. I mean, the facts are, they're very different to what's in this case, but if you look at the language of what a carve-out is, both before the High Court, the Court of Appeal, the Supreme Court, it's very, very different to the absence of language in our case. And the point I would make is, if you're going to expect to see that carving out collective bargaining in an industry where collective bargaining is the root of how terms and conditions are changed, you'd expect the types of language, types of express wording that you see in Tesco. So if I take you first to the authority, which is I presume it's going to be in divider 2, bundle 2.
24, I think.
24, yes, correct. Lordship. Now, in Tesco, the Supreme Court found the exception to relying on pre-contractual statements was met because of the flexibility of collective agreements. So they are actually analysing the mutual consent clause that you've been taken to through what the pre-contractual statement said between Usdaw and Tesco. We say that's an important point when you start looking at the pre-contractual statements. And the reference where the Supreme Court deal with the principle that they could rely on pre-contractual materials is at page 587 of the bundle. It's paragraph 5. It's between G and H. The parties agreed between themselves they could rely on pre-contractual statements. It's at G, my lady, my lord. In the light of the parties' submissions, but also because we acknowledge the need for flexibility in the context of collective agreements, we shall treat the pre-contractual material relied on as admissible aid to interpretation. So relying on the fact the parties were happy to do that. However, had it been necessary to do so, we would have regarded the pre-contractual material relied on as coming within the exception that explanatory material should be admissible in interpreting a contract. As I'm on that page, if I may, top of paragraph 4 talks about this two-stage process, which we're dealing with here, collective agreement followed by individual contracts of employment. The thing obviously differs from the usual way in which contracts are made, but there's no particular difficulty in applying the usual objective and textual approach to contractual interpretation. And it goes on at C. In the collective bargaining setting, the same objective and textual approach to interpretation applies, but importantly, that objective and textual approach applies to the interpretation of both the collective agreement and the individual contracts of employment. Now, you've been taken to the express term. I should say the collectively bargained retained pay right was incorporated not by an express term but by custom and practice. So it's slightly different to our case, but it wasn't an express term, but nonetheless it was still incorporated into the employment contracts of the employees. But going back to what the express wording says about retained pay in the collective agreement, that's at the bottom of page 589. My learned friend's taken you to that already, but I want to take you to it again and make several points. Now, at the top of 590, you've seen where it says retained pay will remain a permanent feature of employment contractual eligibility subject to the following principles. So the first point is you haven't got any language like that in 5.1. And it's very clear retained pay can only be changed by mutual consent. As Nicholas Underhill suggested, that is arguably, the language can only, is arguably removing collective bargaining. So the language of, express language of the collective agreement gets incorporated has expressly fettered the rights of collective bargaining to change this term. But they don't just stop there, the Supreme Court. They go through and look at the pre-contractual material to properly understand what was the common intention, what the reasonable observer would have understood the common intention in this case of Tesco and Usdaw to have been. And there are several documents. The first one that starts, you see at paragraph 23, my lady and my lord, at the bottom of 590, you have this Tesco document called a compensation package summary. And it was in tabular form. And it explained what staff would get if they moved to Lichfield or any other Tesco site with a new Tesco contract. For those who choose to remain in employment, it was said that there would be new terms and conditions supported by individual retained pay protection for life at new Tesco contract site. Please refer to previous joint statements. And the next document is a question-answer document, again provided by Tesco to staff, and there are a number of questions and answers. But the particular one I want to take you to is it must be question 33. Or question 33. What does retained pay mean? Have you got that overlaid?
Yes.
If you transfer to a newly opened site in Tesco distribution, you'll be on a new contract of employment. However, any difference in value between your old contract and your employment contract will be protected by this concept for retained pay, which remains for as long as you're employed by Tesco in your current role. And then this is the key words. Your retained pay cannot be negotiated away by either Tesco, Usdaw, or Usdaw shops do it. So very clear express wording being used by the employer saying what it says. Then further down, you have this joint statement of paragraph 25 of Tesco, which Tesco and Usdaw, and it's the bit in italics. You see the retained pay is guaranteed for life.
Same page, sorry.
Same page, apologies. Yes.
Sorry, under which one? Under.
It's a joint statement.
Yes, I see.
And then you see how the Supreme Court do it. The important ones they put in italics. retained pay is guaranteed for life.
Yes.
Now, again, moving on, the January 2007 documents regarding Livingstone. This was communication from Tesco's Regional Distribution Director, Mr. Hogan. He writes to the staff relocating to the Livingstone depot, and you'll see in it, we have secured a process to protect the value of your existing contractual terms and conditions for the remainder of your employment with Tesco. And within that letter, there's another document, enclosed questions from briefings, commencing on that date in the Livingstone depot. And you've got several questions here. Will retain be guaranteed forever? Yes, providing your circumstances don't change, but it's really question 8 I want to take you to. Why change the contract if we're not losing any money? Answer. We want to introduce the concept of retained pay to ensure that there is long-term protection for you. And then making retained pay an individual contractual entitlement prevents any possibility of this being subject to negotiation or change in the future via a ballot of the membership, of which existing staff would be in the minority. Retained pay ensures this will never happen. And then paragraph 29, there appears to be a further document by Usdaw for its members for the proposed terms agreed for the Livingstone depot. And among these principles, it states to be guaranteed protection of these arrangements. They cannot be altered by Tesco, Usdaw, or Usdaw shop stewards in future negotiations at the new site. So in terms of going back to that two-stage approach, looking at what's the objective intention of the trade union employer, it's pretty obvious. The objective intention, if you read mutual consentment and these pre-contractual statements as an aid to construction, it couldn't be a clearer carve-out.
But it's not saying you need clear carve-out words for there to be a carve-out, because do they rely on the pre-contractual material for the purposes of interpreting the retained pay provision? Or
Yes,
do they interpret it separately and then saying this is reinforced by or this is supported by?
I mean, it's an important point, my lord. I mean, I understand this authority, and my learned junior will check, is they are using the pre-contractual material to interpret the express term.
Yeah.
Because that's what the purpose of construction would be, inevitably. That they're allowed to, there's an exception to the general rule, to use pre-contractual material to interpret the express term.
But your submission was that you would expect to see a carve-out similar to the language that was used in Tesco if there was intended to be a carve-out. And what I was asking you is if you just read the clause, there is no, on its own, without reference to any of the pre-contractual material, because we do not have pre-contractual material here, you have to just interpret on the basis of what it says.
Correct.
You can distinguish our case by saying, by reference, by pointing out that in Tesco there was admissible material which said in terms that collective bargaining won't apply. But you can't go further and say that it said you would need to have such express terms in order to exclude collective.
No, I'm not saying that. I'm saying, first of all, I grounded the first part of the submission is just the express term, which we looked at, can only be changed by mutual consent. That on its own makes the point for me that there's nothing like that in 5.1. That is one construction of that is excluded collective bargaining very clearly, can only be changed by mutual consent.
I suppose what may or may not be my lord's point. I'm interested how you're using Tesco. You're explaining why it doesn't help Ms. Mayhew. Are you saying it positively helps you, or it's neutral?
Well, I say it's a good example of the sort of language you would expect to see in 5.1, if it's having the effect the claimants say it should. Because
For myself, I don't understand that, because it's just a matter of interpretation. And I don't understand the expect to see. Sorry, I interrupted
No,
you
not at
anyway,
all.
mid-sentence or mid
No, not at all.
submission.
The Tesco shows the type of language that would support a carve-out of collective bargaining in the context of Tesco's. That's what the language showed, and what the especially it's the objective intention of the parties. And that's what I'm talking about. The first stage is between the employer and TUI, the employer being Tesco's and Usdaw. This is all material that goes to what the objective intention of the reasonable observer would understand, and it was there very clearly carving out collective bargaining. And you don't have anything like that in 5.1 to support for the reasonable observer to construct it in that way.
Yes. But
And I suppose that the other point I'm making...
I'm picking up my Lord's point about expect to see. If all you're saying is, if you were going to have an express exclusion of collective bargaining, this illustrates how you might do it. Fine, I've got no problem with that.
That's what I mean by expect to see.
Yes, but you can't.
I'm not saying it has to
There's
be
nothing
that.
in Tesco saying that you either a hard rule or a soft rule that without such language, collective bargaining will trump everything.
No, it's a tool for construction ultimately. The absence of those words and the absence of statements.
the point made against you is that is the absence the absence both ways, because as you say, if you look at the pre-contractual material in the Tesco case, it was made abundantly clear what the effect was. There's nothing in our case that makes it abundantly clear in the same terms as in Tesco.
Sorry, forgive me.
But Tesco, it was present. In our case,
The wording, you mean?
In the pre-contractual material, made it clear what the provision meant. But if you didn't have any of this pre-contractual material, as we don't, where do you go?
Well, sorry, a little bit.
No, because the point made against you by Miss Mayhew is that if you wanted to, as she puts it, change the wording of 5.1, you need to put wording in similar to the opposite effect of what was in Tesco. In other words, this does not apply to collective bargaining or the effect of collective bargaining.
And I suppose perhaps I'll deal with that when I come to the actual, when we start looking at 5.1. But
in truth, when a fairly familiar situation arises slightly oddly because of collective bargaining and so on, but in many contractual disputes, one side says, well, they could very easily have made an express provision for this, and they probably both say it sometimes, and it doesn't ultimately help very much. If they had, we wouldn't be here.
no, of course, and that's why looking at the literal interpretation, the wider contract, and the factual matrix, which I will obviously take you to. I think the other point before I leave Tesco is that, but for the collective bargaining carve-out, Tesco could have changed this permanent right. I think would be what I'm saying.
Well, but for the proper interpretation of that provision.
Of course, yes.
Yeah,
But there's nothing. My point goes back to that foundational principle at the start. I said, or trite law, parties can change terms and conditions between them. Now, my lady, my lord, I'm not going to deal with the collective consultation versus negotiation point, unless you want me to take you through the difference between negotiation and consultation, save for when you are constructing or construing the first sentence of 5.1, the qualification of consultation, not negotiation, is an important one because it goes to exercising unilateral right, supportive of TUI's construction on that. and I should have said as well that the point that was being that my friend had made against me, you should expect to see words on our side. Well, the case, for example, Amdocs, or in the case she's referring to, that these are unilateral changes. They're not about changes through agreement and through consent, which is really what this appeal is about. And I'll make good that point further on. So, if we go to 5.1, if I may. Well, actually, before I do, if you'll indulge me slightly, I just want to take you back to Wood, just one short sentence from Lord Hodge. And that was at paragraph 10 of the judgment, and that is at page 234, which, just bear with me, I'll give you the tab. That's at tab 15. I should have asked you, where do your tabs in bundle 2 start?
They start at 7. They start at 20.
20.
Yeah.
Sorry, what tab did you say again?
This was tab 15.
Whenever I look at these cases, I'm reminded of Lord Justice Jackson, previous rather waspish observation of how grateful we are to the Supreme Court for having, on 5 separate occasions, given us valuable guidance about the correct approach to construction, in each case helpfully explaining what the previous case had meant.
Yes, which this one says there's no
But this
change
is the last
whatsoever.
one.
Yeah, it's the last one saying there's no change whatsoever. It's paragraph 10, so that's at page 235. It's by B. My learned friend's taken you to, but it's this bit I want to take you to again. It's long been accepted it's not a literalist exercise, focused solely on the parsing of the wording of particular clause, but the court must consider the contract as a whole, and then there's this degree of flexibility depending on the formality and quality of it, whether how much weight you give to the background matrix of fact. Now, that's the clearest statement of what the current position is. And the reason I take you to, but the court must consider the contract as a whole, in a moment I'll take you to, the judge actually does consider the seminal provision and the effect of it when construing 5.1. My learned friend didn't say that was part of the wider contractual interpretation, but it's an important one because the judge says, well, because of the seminal provision and the existence of it, and the fact the employees already agreed that into their contract of employment, I would expect words carving out collective bargaining and basically neutralising that incorporating term to be in 5.1, and it wasn't. So, if I can take you to the clause which it's in 2 places actually. I've highlighted it. I'm conscious you would have highlighted it. It appears in the core bundle and the supplemental bundle, but you've been highlighting it in the supplemental bundle before.
We have.
Yes. Okay. If you bear with me 1 minute, I'll get my version out first, and then it was at 59.
How long is this part of your submission?
Oh, I think it's not going to be done in 4 minutes, my lord. No. The best will in the world.
So should we would sensible stop there then? And you're doing pretty well.
I think yes.
Good.
Whether I'm persuading you in terms of time.
No, it isn't. Yes, it's a good observation. What did my question mean?
We need some context.
So how much longer?
Well, given I've dealt with 2 and 3,
just very broadly.
And I'm sorry, I'm looking at my doing an hour maximum hour. He's not looking at me.
An hour and a half.
Hour and a half maximum.
Okay.
And if I can do it earlier than that, I will do my best.
Thank you. Hold on a second. Yes. Thank you very much.
What, Ryan?